and I will recommend to my successor that we come back to it.
Thank you, Mr Chairman. I apologise to the Honourable David Parker. I just want to take a very quick call just to, I thought it might assist the House if I indicate that the Government will be supporting SOP 62 in the name of Jacinda Ardern. So if it saves the House time debating the point, just to make it very clear at this early stage that we accept a lot of what Ms Ardern said in her comments. We do believe the place for it is in the Constitution Act, but nonetheless we're persuaded that there is certainly no harm in maintaining it in the interim, but I certainly welcome the record in Hansard that when the appropriate time presents itself, we would like to see that it be removed from this legislation and placed in its appropriate place. But I thought it might assist the House to clarify that point, and I apologise to Mr Parker.
The Honourable David Parker.
Thank you for that indication, Minister. Can I also just put on record that in the Labor Party we were somewhat reluctant to agree to a single debate here. We wanted a part-by-part debate because this is a very serious piece of legislation governing all of our courts. But we were presented with the option from the Minister that if we agreed to a single debate, we would remove the uncertainty as to whether we would get the National Party vote for this supplementary order paper. And having spoken with my colleague Jacinda Ardern and discussed the pros and cons of that, actually this is such a fundamental provision in this bill, we thought we should bank that. That was the most important thing that was going down at this committee stage, and we should get it through. I suspect when the final votes come, we already know that we've got the good support of New Zealand First and the Greens. I suspect we're going to get support from other minor parties like Peter Dunn and get it across the line anyway, which is why the government might have rolled on it. I do not know. The Minister shakes her head. She may not know either. So, that might be a little bit cynical of me, but this is supplementary order paper 62 that I'm talking about. So, Mr Speaker, Mr Chairman, having in the Supreme Court Act put that provision in there, you've got to consider what would be the effect of taking it out. Even if it wasn't necessary to put it in the Supreme Court Act, and arguably it wasn't, it was just stating what was the underlying position at law, it having been in there, for Parliament to withdraw it in this iteration could actually change the law. So even if the original provision was not necessary, to actually omit it from the replacement legislation for the Supreme Court and other courts below it in the hierarchy of courts would have meant that the law meant something different to that which it meant before that provision was in there. And that would have in itself created uncertainty that is best avoided. Now, I agree that this provision is best sitting in the Constitution Act. But actually it's the same effect whether it sits in the Constitution Act or in this Act. It is of the same legal effect. And it would be of the same legal effect not to have it. Sorry, that's not quite good English. The effect of not having it would have had legal effect, whether it doesn't sit in the Constitution Act or it doesn't sit in this Act. It needs to be in one of these pieces of legislation. That is the most important issue, in my opinion, in this debate that we're having. Because by and large, the rest of the legislation, I think the Select Committee's done a very good job on and reached agreements that I can concur with. And I'll say one final thing. Equity and good conscience jurisdiction is reduced, is going up to $5,000 on the recommendation of the Select Committee, but not up to the full amount of the jurisdiction of the Disputes Tribunal, which has a jurisdiction of, I think it's $15,000, can be a bit more if people agree. I agree that the Select Committee's got that right. There is rough justice in the Disputes Tribunal, and it is rough at times. You've got limited rights of appeal. They have an equity and good conscience jurisdiction, which means that they don't actually have to follow the law. Even their process protections are pretty thin compared with traditional courts. Now, the answer to people who have got serious legal problems lies in the courts, and I think we should be careful not to say, oh, anything goes, we'll just throw the dice up in the air and see where it lands on the basis of how someone feels on the day on an equity and good conscience basis. We should actually make sure that our courts are accessible so that the rule of law can be applied rather than brushed over. Mr Chairman, with those comments, I will take my seat, and I'm so pleased, I really am so pleased that Jacinda Ardern's supplementary order paper that I've also been advocating for is going to be passed.
I call Dennis